It it depends on facts. Bad facts create bad case law, and so we don't want to argue something that we think the Supreme Court is then going to use as a means of creating case law that's bad for us. And so, if it is just an adult sitting in a passenger seat, I'm probably not going to argue it. If it's kids in the back seat, if there's a crash and the person gets hurt, I would argue those because those aren't bad facts. Those are good facts for us to show this is another person put at risk. I don't think there's a case directly on point that says, yes, that is another person and that's good enough. But the point being, in your narrative, make sure you describe how that person is driving and how they are putting other people at risk after you activate lights and sirens. I had one recently. So in our office, I guess I might touch on this later, but essentially there's been a change in the law that essentially created a constitutional right to be released. So when you make an arrest, under the law, that person gets released the next business day. That is what the law says has to happen. They are not allowed to be in jail. The only way we can keep somebody in jail is if we file a motion for pretrial detention. And so in our office, that's me. I do all of those, and there are certain categories of cases that I look at and decide whether or not I'm going to file pretrial detention. Ag fleeing is one that I look at every single ag fleeing. I look at every single one and decide, am I going to file pretrial detention on this one? And sometimes the narrative is not clear enough for me to do that because I will read it and there is super bad driving. Like they'll describe, the narrative will be fantastic as to why the officer activated lights and sirens because of how bad that person was driving. But then they don't describe much after lights and sirens. And then I'll look at that and be like, well, I don't know if I can prove ag fleeing based on this narrative. And so then I won't file pretrial detention. We still go forward on the case because we got to wait and get all the discovery, and then the video will be probably pretty clear. But for pretrial detention, I'm making the decision on the PC statement, which is why I'm going to touch on why we need a clear narrative.
So you mean after the guys are writing the narrative, not per se here, I don't know if I write that here, but they're not putting in that they ran the vehicle over or ran the stop sign.
Sometimes. Yeah. I have said no to pretrial detention on some ag fleeings because it was unclear. Yeah. And what happens then is I say no to pretrial detention, but then it goes through our intake process. It gets set for a prelim. We try to get all the discovery. Someone will watch the body-worn camera video. They'll watch the dash camera video. They'll get the full report, which sometimes has more details. And then they'll decide if that's enough. I'm just looking at it for pretrial detention. And for pretrial detention, I have to do a prelim, which is essentially a trial where the rules of evidence apply within 2 weeks of their arrest. So, yeah, that's for PC. Yeah. All right. So ag fleeing, it's important that other people are put at risk after you activate lights and sirens and you're in uniform and you're a marked unit. Questions about ag fleeing?
There's one question on the uniform, your rain jacket. Now, if you're going to the gym, we're not supposed to do it anyway. Go to the gym and you're driving your marked unit, sweats and t-shirt. Yeah, that's not a uniform by any stretch of the imagination.
No.
But you throw a rain jacket on, is that a uniform? That's a badge on it? With a badge,
if it's got a badge, is it similar to what like we see Shannon wearing there? Yeah. I would say yes. Something that would identify you as an officer, even though we know the person driving the other vehicle doesn't see the driver of the marked unit. As long as it's something, I would say that they've got to have it on when they activate lights and sirens. You can't activate lights and sirens, give the chase, and then once they pull them over, throw it on and then get out. Yeah. Let's see. Anything else I need to cover about that one?
Yes.
Okay, let's see. There was a case in Las Cruces. New Mexico State University police officer was on a high-speed chase. It was 3 a.m. The roads were slippery and wet. The defendant raced down a main street going over 70 miles an hour. He crashed into a road sign. The Supreme Court held that the statute doesn't mean another specific person has to be put at risk. Instead, it asks if a person could be put at risk. And so that's State v. Vest. So that was in Las Cruces. Yeah. All right. Any other questions about ag fleeing? Okay. Yeah. All right. Next, we're going to cover pretextual stops. Some of this is going way back several years ago to State v. Ochoa, which is back in 2008. In that case, State v. Ochoa, they were watching a drug house. I want to say it was Albuquerque. But they were watching a drug house. They saw clearly things that were happening that looked like a drug action going on in the house. You know, the people showing up, not there for very long, and then leaving. And they decided to follow one of these cars. And the detectives who were watching the house got a hold of, because they were in unmarked units, they were undercover basically. They get a hold of a marked unit, a patrol guy, and was like, "Hey, pull over that car." And that guy was like, "Okay, boss," and like just pulled over the car with basically no real reason to pull over the car other than the detectives really wanted to talk to that person. And the Supreme Court held that that was a pretextual stop. Anything found during that stop is no good. Um, this is where the New Mexico Constitution deviates from the U.S. Constitution. The New Mexico Constitution grants the citizens of New Mexico or anybody passing through greater protections than the federal standard. And so sometimes you might talk to federal guys and they'll be like, "No, that's good. You can do that." It's like, "Nope, not under New Mexico law." And you can't be sure that the feds are going to take the case. And so you got to make sure that you have a reason for stopping the vehicle. Um, uh, yes, the standard is basically a reasonable officer with the information they had would have made that stop. And so if the detectives, yeah, and then you're a patrol guy and you start following that vehicle, and then you see a traffic infraction, you see some other reason totally independent of that tip to pull over the car, yes, that's okay, but you got to make sure it's good because the courts are going to look at that very closely. So if it's touching the line, yeah, that's failure to maintain lane, but that's not going to be good enough. You want a real thing where any officer driving down the road would say, "Whoa, I've got to pull that car over." That's how you want to address it. Okay. Let's see. One way I like to phrase this is that once you become an officer and you put on your badge and your uniform, the 4th, 5th, and 6th Amendment to the U.S. Constitution and Article 2, Section, I'm messing it up, Section 10 of the state Constitution now stands between you and everybody else. Like, you now have to overcome those constitutional rights. The U.S. Constitution and the New Mexico Constitution protects the citizens from you, even though you are out there to protect them. So you have to have a reason for everything you do. So you want to make sure that you have a real reason and you articulate it well. Let's see, what do we have here?
So let's say our decorate some citizens. We're driving on the road, knowing that mistake necessarily license plate, insurance plate, driver's license. They be protected too.
Yes, they are people. They're protected in the sense that you have to have a reason for doing it. The 4th, 5th, and 6th Amendment does not stop you from enforcing the law. It just says that you have to have a reason to stop the law, a reasonably articulable suspicion that somebody has committed a crime. And so a sovereign citizen, that's actually pretty easy because they've got a fake license plate on there because they are not boarding our ship when they get on in the courthouse. And yeah, yeah, well, I've dealt with a few sovereign citizens, and those cases are usually pretty easy to prove. Yeah. Yeah, in Doña Ana County, a deputy stopped a vehicle with a cracked windshield. The deputy felt that that was enough for reasonable suspicion. It has to obstruct the vision enough to be a safety hazard, to be an unsafe condition. And that's a 1998 case, State v. Munoz. And so just a crack by itself, not enough. It has to be enough to impede their vision to where they become unsafe. In 2021, the Supreme Court of New Mexico said a taillight not in perfect working order, a bulb might be out, but one could still see the light, is not reasonable suspicion to stop the vehicle, and that is State v. Farish. And so, if you can see it, like you're at night, you're behind them, and you see one that's bright, and you're like, okay, that one's working. And then one that's kind of dimmer, like, well, that one's not working. That's not reasonable suspicion. Pull them over because you can still see it. If it's totally out, that's different because you cannot see it. But if you can see it a little bit, then it's not out. There was another case. A New Mexico State police officer on I-40 near Grants saw defendant's vehicle pass 2 semi-trucks. The driver was stopped after briefly touching the yellow line. Officer looking for drugs had a long conversation with the driver and got a consent to search. The officer found methamphetamine. The Court of Appeals said briefly touching the yellow line of the passing lane as defendant was passing two semis was not reasonable suspicion. And so the trafficking charge was dismissed. The drugs were the fruits of an unlawful search, and that is a 2017 case, State v. Valenzuela.
So they gave him his best back.
The letter of apology. That would have been different. Yeah. But it's that touching the line. I've done a hearing. It was a while ago, but I did a hearing where we did the touching of the line, a reasonable suspicion, and it was in district court in front of Judge Pfeffer. That's how long ago it was, if you remember Judge Pfeffer. And I actually was able to show reasonable suspicion because the defense, he made a dumb argument. He was like, well, it's to like touching the wall to a room. And Judge Pfeffer was like, well, no, that's actually, there's a gap in that wall, and he broke through part of the wall. He might not have gone into the other room, but he broke the wall. There's a broken wall there. And so the defense actually helped me get past reasonable suspicion by their dumb argument.
But I mean, that was done that on the DWIs. The guys were like, oh, well, they hit the line. No, did they hit it or cross?
Yeah, we want to cross over is really what we want. The way I would phrase it is when I watch the body of the dash camera video, it'd be fantastic if as we're watching, we can go, whoa, please pull that person over, not gotcha.
Back in the day, the whole center line of the hood, you put it on the yellow line on the fog line, and you just drive over.
All right. Next, any other questions about kind of that reasonable suspicion to stop a vehicle? Okay. Then we're going to, once you stop the vehicle, who can you talk to? Yep, you can talk to the driver. Let's see, we got State v. Teuton in 2020. In Las Cruces, an officer stopped a defendant for running a stop sign. Where are you coming from? A friend's house. What's his name? Josh Demas. And the officer remembered, Demas, the convicted drug dealer? The officer asked to search his vehicle and did a pat down. The officer found methamphetamine. The Court of Appeals held the question was not reasonably related to the stop, and so they suppressed the methamphetamine. So keep the questions related to the stop. And sometimes the questions could expand it a little bit. That's how we do a DWI. Like if you see maybe even some bad driving, but you see like an expired license plate or something, and you pull them over, you have a reasonable suspicion to pull them over. And then as you're talking to them, you're like, ooh, you smell of alcohol. That's bloodshot water in his eyes, slurred speech, the holy trinity of reasonable suspicion. You can then expand your questioning to, okay, how much have you been drinking? Things like that. But just saying, yeah, I came from a friend's house, and he's like, well, I'm pretty sure that's a drug dealer. Let me search. That's not good enough. We got another 2008 case, State v. Funderburg. A Rio Doso Downs officer stopped the vehicle for possible forgery. A passenger in the front seat was the suspect. He was arrested after the officer found drugs on him. He asked the driver 2 questions. Is there anything in the vehicle I need to know about? Mind if I search your vehicle? The driver gave consent, and the officer found methamphetamine. These 2 questions went all the way to the Supreme Court. They felt the questions in this case were appropriate. The officer had just found drugs on the passenger. So because the passenger was part of the reason for the stop, they find drugs on him. And the officer wanted to search the vehicle, not the driver. So that was okay. You just have to make sure that you are reasonable when you are asking questions of the driver. What about the passengers? In 2023, we have State v. Vasquez Salas. Just before dawn in Clovis, an officer stopped a vehicle with a broken taillight. The driver didn't have a license and lied about his age. In the back seat was a partially open backpack that had bolt cutters, gloves, and a camouflage mask that went over the entire head. So more than just a COVID mask back in 2023. The officer asked the passenger for ID to see if he could drive, because he's not going to let the driver drive away. So, hey, passenger, can you drive? The passenger didn't have a license. Was it appropriate to ask the passenger for his ID? What do you guys think? Is it okay? Yeah. Not to ask them anything, but in this case, they were asking the passenger because, yeah, are you able to drive this car away? It's reasonable to say, do you have a driver's license? So the Supreme Court did say, yes, that was an appropriate question. The officer had investigated nearly 100 burglaries, and new cutting tools were often used in burglaries. Also, the driver didn't have a driver's license. and the defendant was convicted, the driver. Actually, this write-up doesn't say who the defendant was, driver or passenger, but was convicted of burglary tools. So this is another time where the New Mexico Constitution grants greater protections to people than the U.S. U.S. Constitution. So especially for passengers.
I don't know tickets, but you stop a car, right, and the passenger's not wearing their seatbelt. Well, the passenger's required to wear a seatbelt. So now I can.
You can ask them questions related to that.
Related to the seatbelt and cite them for not wearing their seatbelt.
Yes, and you might need to ask for ID to be able to cite them. Yep. So that should be fine. You might need to just ask the driver to step out, like, look, I can't talk to you. I keep getting interrupted. But you can't start talking to the passenger just yet. So all the questions during a stop must be reasonably related to the reason for the stop and supported by that reasonable suspicion that we talked about. Officers usually don't ask questions of passengers or ask for ID unless there is a reason to do so. So when you have a reasonable suspicion to stop the car or the driver, you're talking to the driver. And so you can only start talking to the passengers if you have a reason to start talking to the passengers. Remember, the U.S. Constitution and the state constitution protect the passengers from you. And so you have to have a reason to talk to them. All right. So now we're going to talk about Miranda. Good old Miranda. All right. Let's see. Some updates about Miranda. Let's see. State v. Atencio in 2021. Officers told a suspect that he had a right to a lawyer during questioning. The Court of Appeals reversed his conviction on criminal sexual penetration because he wasn't told he had a right to an attorney prior to questioning. Let's see. That was a 2021 case. Then in 2024. Oh, it's the same case. So State v. Atencio. So that's what the Court of Appeals said in 2021. That went up to the Mexico Supreme Court, and they reversed that. So they held that saying one has a right to a lawyer implies the right to a lawyer prior to and during interrogation. So that was somewhat helpful, but there's always been kind of some confusion as to what's going on with Miranda. Let's see. In 2024, in San Juan County, a defendant was assigned an attorney who told him not to talk to anyone, including the police. That suspect was in jail. The next day, the police went to see him to hear his side of the story. The charges were serious. 2 counts of criminal sexual penetration with his daughter. He gave his side of the story and is now doing 30 years. The Supreme Court said an adult, not a juvenile, that an adult with an attorney can make a decision to talk with police without their attorney. That is State v. Mares. And so that is a guy saying, yep, my attorney told me not to talk to you, but I'm willing to talk to you. So an adult can make that decision. Yes, because this Miranda made up a right to counsel that did not exist before. So there's a 6th Amendment to the Constitution that has a right to an attorney for an accused. That's what attaches at arraignment. That's the 6th Amendment right to counsel. Miranda's not based on the 6th Amendment. It's based on the 5th Amendment right against self-incrimination. And so that's why it was so weird when Arizona v. Miranda came out, was because the U.S. Supreme Court was like, this 5th Amendment that never had a right to a counsel before, we're going to say that it does now. And it just created this kind of, we're all walking around with this right to an attorney, which did not exist before. What's important to note about Miranda, some of this is maybe not updates so much as just reminders about old things. Miranda applies for people who are in custody and are being interrogated. Yep, not free to leave. That is when they are in custody. So if you're talking to somebody on the phone, are they in custody? No. So you don't necessarily have to Mirandize them. And then I have a hard time believing even our Supreme Court would disagree with that, but who knows? Bad facts create bad case law. We'll see what happens. So they have to be in custody. If they're not in custody, you don't necessarily have to Mirandize them. It could still be a good idea. But I'll leave that up to to you guys with your internal policies and procedures as to how you want to do that. Do they feel free to leave when they're in the back of a police car? Yeah. I don't even know if I have a slide about that issue, but we should. I could do a whole day training on that issue with tribal officers stopping somebody and then calling you guys to come and clean that up. Oh man. So what was that? So in custody. And then here's the other thing I want to touch on because we often ignore it: an interrogation. An interrogation is anything designed to elicit a response. It does not mean questions. Okay. There's a U.S. Supreme Court case that talks about this guy got arrested for essentially murdering a little girl. And he invoked his Fifth Amendment right to counsel. I was like, I'm not going to say anything. And so the two cops, they put him in the back of the unit and they're driving. And they happen to drive by a cemetery as they're taking him to the police station. And these two cops talking to each other like, oh, the cemetery. Wouldn't it be nice if these parents had a body that they could bury, that they could go and visit their daughter? I mean, it's just awful that they don't. And the guy's in the back hearing all that. And he was like, okay, I'll tell you where she is. That was an interrogation. Even though they were not asking that person any questions, that was an interrogation. Yeah. And it was, whether they meant it to be a tactic or not, it was a tactic. And where this really comes in, like every day for you guys out on the street, however many of you are still out on the street, is sometimes you arrest somebody, you Mirandize them, they're like, yeah, I'm not going to say anything. You're like, okay. And then you start to put them in the back of the car, and they're like, well, I'm going to say this. So they're allowed to do. They're an adult that can make their own decision. They make a statement. And then you're like, really? Boom, interrogation. You have now interrogated them. And anything they say after that is not admissible. Anything they said before that, I can use, and we can parse that out. But anything they say after you do anything to kind of get them to keep talking, it's not going to be enough. What do you mean by that? Well, tell me more. Like, all of that's an interrogation. Don't do it. Once they say, I want an attorney, keep your mouth shut and let them talk. Because anything they say is allowed. But as soon as you do anything to help them, even to clarify something, that's now an interrogation. If you stay quiet and they talk for a bit, and then they kind of stop, then you be like, you've said some things. Here's your right to an attorney. You do Miranda again. Do you want to talk to me? Have you changed your mind? And they be like, no, I don't want to change my mind. But I just need you to understand this. And then they start talking some more. That would be okay. Okay. But once they invoke their Fifth Amendment right to counsel, anything you do that could elicit a response is an interrogation. So don't do it. All right. Getting into search and seizure stuff. New Mexico hates warrantless searches. And as we go through this, we're going to talk about some of the exceptions and things like that. It might seem like where I'm saying, okay, here are some things you can get away with or things like that. That's not what I want to come across. I want you to remember our courts want a warrant. Get a warrant. Get a warrant. All right. So we've got, actually, no, before we do that, there are a couple of cases I was going to talk about with Miranda. There was one other case. Nope, I already talked about that one. Okay, we're good. All right, searches and seizures.
They just changed the new thing where we arrest someone that has a backpack. You can't search it without a warrant. No, it is.
Yeah, that's a search incident to arrest. I think we're going to cover that one. Yeah, so that search incident to arrest is what that case gets into. I think, is that State v. Garcia? I can't remember. State v. Ortiz.
Yes.
Yeah, State v. Ortiz. We're going to talk about that one. We're going to build up to it first, okay? So starting with inventory searches of cars. So there are 3 things you have to do before you can do an inventory search of a car. You have to have control and custody of the car. The inventory search is conducted in conformity with established police regulations, and the search is reasonable. What reasonable means, who knows, and that can always change. Reasonable is determined by balancing the need of the search in a particular case against the intrusion upon the individual's privacy interest, which is not awesome. So State v. Jim from 2022, there was a warrantless search of a locked gun safe inside of a seized vehicle. It was not reasonable because it had little, if any, utility for inventory purposes, and the search infringed upon a substantial privacy interest. So when you do an inventory search of a car you're towing, what's the purpose of that? What's the purpose of an inventory search? Document valuables. Yeah. So you guys don't get sued. Like, hey, my priceless Van Gogh painting is missing. What'd you do? And you're like, no, I inventoried it. There was no Van Gogh painting. Searching a locked safe inside there, nobody's taking anything out of that safe. You can't get into that safe. And so anything missing from that safe, they're not going to be able to sue you for. So it's beyond the scope of the purpose of an inventory search. We just had a recent case, 2025, State v. Huerta. The court held that a defendant had a privacy interest in a closed cylindrical Fritos corn chip canister found in an open backpack on the vehicle's floorboard in the front seat of the driver's seat. The court also stated that closed, locked, or sealed containers that obstruct a law enforcement officer's view found within the vehicles during an inventory search may not be searched without a warrant or the existence of circumstance otherwise justifying warrantless entry into the container. Not awesome things. And so it really, really limits what you can do during an inventory search. Let's see. Yep, just covered all that. Just get a warrant. If you want to look in there, because sometimes officers will call me up when I'm on call, and they'll call me and say, hey, these are the reasons I want to open that and search it. I'm like, all of that sounds like probable cause. Put that into a warrant. Just get a warrant. The canister's not going anywhere. Car's not going anywhere. You've seized it. You've towed it. Get a warrant. All right. Pockets versus purses. This is that State v. Ortiz. So a search incident to arrest, you need two things happening. The thing must be in the area of that person's immediate control, and the search is limited to the physical area where a defendant might gain possession of a weapon or destructive device. Because a search incident to arrest, why do you do a search incident to arrest? What? Weapons, officer safety. You can't be putting this person in the back of your unit if they might have a weapon on them. So you got to make sure it is for safety. And so what State v. Ortiz did, it said, well, that's our focus. Under the state constitution, not federal constitution, under the state constitution, it's for officer safety. And so if you take the backpack or purse from them, and they're in the back of your unit, and the purse is sitting on the hood of the car, it's officer safety, you don't need to search that. In State v. Ortiz, the police arrested the person on a warrant, removed her purse from her shoulder, and then proceeded to search it incident to arrest without a search warrant or consent. They then found a sealed, hollow flashlight inside of her purse, and they opened it and searched it, finding methamphetamine. The court held that absent evidence that the defendant could reach the purse to access weapons or destroy evidence, there can be no inference that the officer's search was reasonable under the purposes of officer safety. This was a substantial change in the law, this State v. Ortiz case.
So you take her to the jail, and you stroll in there carrying her purse and look her. So jail search.
Yep, that is. So when State v. Ortiz came out, we started talking about this. This actually came up constantly. Yeah. So what I'm going to say is, you search it. We can't use anything you find. So the jail, when they search it, they've got to do it because you're right. There could be chemicals. There could be anything in there. They put it in their locker. That's safety. They have to search it. But anything they search, we cannot use in the criminal prosecution. So this is I get a call a lot saying, this is a situation I'm in. Is it legal for me to do this? What you're asking is two different things. What you're asking is, if I do this and I find evidence, can you use that in the criminal case? And that's what I'm going to tell you. And I'm going to say, no, you can't. Or yes, that's good and you can do that. The other question you're really asking is, can we get sued if we do that? And hopefully our on-call attorney is never answering that question because we can't do that. You've got a county attorney. Talk to that county attorney. Is it Mike Nunez?
Never talked to him.
Yeah. But that's what he's there for. Oh, is it Peter Valencia? I didn't know he left the AG's office. I did one of my first vehicular homicides with Peter. And so that's why you have a county attorney. They can address the issue of, could you get sued? And so I'm going to say, if you've arrested that person for a warrant and then you've taken the purse or backpack away from them and then you search it, we cannot use anything you find in a criminal case under state BRTs. I'm never going to say, you guys done screwed up. You shouldn't have done that. That's not what I'm going to say. And hopefully nobody in my office says that, because you are the ones on the street making a decision based on everything. I'm going to say, me sitting as a nerd behind a desk, figuring out what I can prove at next week's prelim, I can't use that evidence.
No, if you hook her up and you tell her you're under arrest, she sets her purse down and it's a big bag. You look in there and you know she's a convicted felon. There's a pistol right there. So you,
Sounds like you have probable cause.
yeah.
Get a warrant.
Yeah, that's what.
Yeah, get a warrant. So it goes back to that, get a warrant.
Right. So, I don't know if you guys in the service serve versus it's still a threat because the way society's going now. Yeah, you will go bombs. It's still a threat to us.
Yeah. I disagree with State v. Ortiz. I think it is wrong. I think you need to search it. I'm just telling you, State v. Ortiz says if you search it and you find evidence of a crime, we are not going to be able to use that evidence in the prosecution for that crime.
So they have to have it in their pockets or inside their body.
Yes. Yeah. So that's why this pockets versus purses. Pockets, that's always going to be within their reach. So you got to do a search and arrest for safety. And if you find anything in their pockets, it's going to be good. If it's a purse and it's away from them, not good. Not good in the terms of, again, we won't be able to use any evidence you find in the prosecution. Okay. But I'm not going to say, oops, you shouldn't have searched. Because if you search it and you find a Molotov cocktail, one of those Molotov things, yeah. I'm glad you found it. Thank you for finding it. We're not going to be able to use that evidence, but you did a good job. The place is safer because you've searched it. Okay.
Let me ask you this question though. Because for officer safety, I see where it's headed down the road that it's going to tie into Terry stuff. All you can do is pat them down for weapons or search for weapons. If they've got a baggie in their pocket that's full of weed, well, weed's not legal, weed's legal now, but let's say before weed was legal. Maybe you feel like a handful of pills in there, okay? And you think it's blues or whatever, right? Well, that's not a weapon. That's not going to hurt you. So that's out. Are we headed down that road?
Yes, we absolutely are. Yeah. And New Mexico will have the Seminole case on it, I am sure. But yeah, that's a problem. Yeah. But for pockets versus purses, if it's purse, get a warrant if you have probable cause. If you can't articulate probable cause and you get frustrated with our on-call attorney because the on-call attorney is like, I'm not seeing the probable cause, well, we're not going to approve the warrant, and you might just have to search it and then just deal with the outcome with however it is, or let the jail search it. But again, we won't be able to use that evidence. Okay, so again, when in doubt, get a warrant. Let's see. And we jump to DWIs.
Nobody drinks here.
I was actually really surprised by some of the stats. Let's see if we get to these. Like the per capita have dropped, which is, I was surprised. Like back in the 80s, it was a much higher number. It's been quite. I was surprised when I saw some of these stats. Let's see. I can get to it in a bit. Let's see. So the number of people killed by drunk drivers is going down. In 2024, there were 178. In 2025, there were 129. In the state, and that's from the New Mexico Department of Transportation. Let's see, some current issues to keep an eye on. Let's see. Oh yeah, this is where I saw it. I remember seeing this now. Yeah. So back in the 80s, when it was a 0.10 was the per se standard, 300 to 400 people were killed. But now it's 0.08, and in 2025, 129. Like that's a big, big drop. And the population has gone up. since then. So as much as DWI is a problem, there are good trends.
Vehicles are safer now.
That too. Yeah. So there might be as many crashes, but maybe I didn't give the stats on any crashes, but yeah. Let's see. And the law has been constantly kind of getting updated. Some ways it's good, some ways not so much, but we can start to lock people up for those really high level DWIs when they start to get into their 4th, 5th, 6th, 7th, and even 8th. The law stops at the 8th. Yeah.
And, since July, now that we can get search warrants for a blood draw on a misdemeanor DUI, have you seen a trend taking plea deals as opposed to back when they would just refuse and we wouldn't get a warrant for a blood draw, and so we didn't know what their blood alcohol content was. We might lose the case, but now that we're getting search warrants, we're getting the blood showing that they're above an 08. Just take more like plea deals for those.
It's probably a better question for somebody else in my office that deals more with the Santa Fe DWIs. I feel it because I deal with mostly the REREVA stuff now, and pretrial detentions everywhere. I want to say yes, but it also was delayed for a while because a lot of cases we couldn't quite proceed on yet because we don't have the blood results yet. So
I feel like now the results are coming back within like a month. And
when it's alcohol, we are getting it surprisingly quickly. Yeah. Drugs are still taking a long time, and so that's kind of where a lot of the delay happens. I want to say yes, but I can't give you any numbers. Yeah.
I've been involved in, I feel like they're taking pretty quick because they do it. They're screwed, right?
Yeah. I want to say yes, but I haven't seen numbers to back it up yet.
Do you ever say going to like Texas where your third DWI is a felony?
4th DWI is a felony here.
No, Texas.
Yeah, they switch it.
Your third one's a felony.
I don't know if they're going to change that, which makes me think some of our legislature have 2 or 3 prior DWIs, and they don't want to do that. But they did a couple years ago did create the 8th or subsequent, which has a mandatory 10 years of incarceration, whereas before I want to say it stopped at like a 6th, but now they've created the 7th and 8th or subsequent. But yeah, it doesn't go beyond an 8th for now. But yeah, you're right. We do see people with 20. All right, so. Some of the things we see all the time: open containers. The statute, the way it is written, the seal has to be broken and the contents partially removed. So there still has to be something in the container. And what our Supreme Court is probably going to really look at is it a dirty car? Because a lot of people are just driving around with cans and bottles, just rolling around, especially if we're talking about a big old pickup truck. You're getting outside of Madrid or something like that. Like, there's going to be open containers. So where is the container, and does it still have something in it? Or if you hold it upside down, is something going to come out? If that is how it is, that could be an open container. But if you hold it upside down and nothing's coming out, that is not an open container the way the statute is written. See, SIMs. Talking about SIMs. So it used to be, old school was, well, they're in actual physical control of this vehicle. So that is a DW. They're drunk and they're in control of this vehicle. They're sitting in the driver's seat. They've got the keys on the dashboard. They are in control of this vehicle. That is a DWI. State v. Sims changed all that. And they said, no, you have to be in actual physical control and have an intent to drive. And what State v. Sims said was, it is okay for a drunk person to use their car as a temporary shelter. We want somebody to sleep it off. We don't want them to say, no, I got to get home. And so if they pull over on the side of the road and they're sleeping it off, under State v. Sims, our Supreme Court says that's what we want. So State v. Sims changed the landscape of DWI prosecution. Then we had State v. Mailman, which clarified it. So in State v. Mailman, there was a car in the middle of the road broken down. It was physically unable to drive. And there was a drunk driver behind the wheel of the car, the dude drunk behind the wheel of the car. And so the cop pulls up and was like, hey, you're drunk. And then the defense argued, Sims, he couldn't have had the intent to drive because the car was physically incapable of driving, therefore you can't. State v. Mailman said, well, hold on, let's be reasonable. There are two different theories of DWI. Past driving, future driving. Past driving is actually what you normally have. Past driving is you see bad driving, you see whatever reason, you see the car moving, you pull them over, you talk to them, this guy's drunk. You saw past driving. Sims says, I didn't see driving, but here this person is, they're trying to start their car, they're doing like that. They have the intent. They clearly have the intent to drive. Where State v. Mailman also throws it in there is, you didn't see driving, but the car is upside down and the wheels are still spinning. This person was just driving. It is those cars pulled over on the side of the road, the hood's hot, they're out, like you have that evidence of past driving. Okay, so that's what State v. Mailman did. So Sims and Mailman kind of work in concert together to do that. Let's see. So we throw this in here, some DWI issues. Write a report. And I'm going to probably harp on that a few other times. Write a report. Even if you didn't do very much, write a report. Under the case management order, we have to disclose all discovery. Not all relevant discovery, all discovery. And so if my baby boy, who's a public safety aide, is out there and he sees somebody driving and he calls a deputy, he's like, hey, I'm seeing this car all over the place. And then the deputy comes and sees the bad driving himself, pulls over the car, stops, and my little baby Jonas Wahlquist doesn't do anything. I need a report from him. He's a witness. He needs to sit through a PTI. And if he doesn't write a report and he doesn't turn over his body-worn camera and dash camera video, that case could get dismissed. And so even if they didn't do anything, another example would be a vehicular homicide. So there's a vehicular crash, fatalities, all the deputies are there, and then you have deputies on the side of the road, or again, my little baby bear. My little baby bear is on the side of the road directing traffic away, and he never actually goes to the scene. We need his stuff. If you do not turn over that deputy's or that officer's stuff, the case could get dismissed, even though it's not really relevant. So they need to write a report.
Even if it just says, I arrived on scene, I worked the traffic, I blocked the road, I didn't have contact with anyone, I didn't speak to anyone. Yeah.
Exactly. When officers have complained to me and be like, well, I didn't do anything, my response is always, and your report should be easy to write. Okay.
This question on PSAs.
Yeah.
Okay. Baby bear sees something. Big old grizzly.
I promised my wife I wouldn't make fun of him, so please. I suddenly realized I was like, oops, I'm going to get in trouble now.
Big old grizzly come help him out. Does police team concept apply PSA to deputy, or is it just deputy to deputy?
Okay. Do you know who Julie Gallardo is at Department of Public Safety? She, I think, does a lot of stuff for the Police Academy for training, and she does a lot of DWI trainings. Julie Gallardo, she used to be a prosecutor in her office. She then left and went to DPS. When you get a chance, reach out to Julie, get her take on this, because this is my take on it. The police team concept is not a thing. It does not exist. It is a made-up thing that doesn't mean anything. Because what you're talking about, a police team concept, what you're talking about is officers arrive on scene, talk to another officer, they get information, and then they make a decision based on what that other officer said. So a classic example would be Deputy 1 sees bad driving, pulls over the vehicle. Deputy 1 approaches the driver, sees the holy trinity of reasonable suspicion, the bloodshot, watery eyes, slurred speech, smell of alcohol. Deputy 1 then calls Deputy 2 over. Deputy 2, the certified, they're a DWI officer, they come. Deputy 2 does the standardized field sobriety test, sees all the clues for driving, for being intoxicated, and arrests that driver for DWI. How can Deputy 2 do that when Deputy 2 did not see the driving? Police team concept. Deputy 1 saw the driving. I cannot use that in court. Deputy 1 is a witness. We cannot prove driving without Deputy 1. Okay? But that's the police team concept. How is that any different than a deputy getting called out to a domestic and talking to a victim? And the victim says, he beat me. And then the deputy makes an arrest decision based on the information they got from the victim. There's no difference. They can make arrest decisions, charging decisions based on any information they got. Deputies tend to be more reliable. That's really what it gets to. But the policing concept is not anything we can use in court. We need reports. We need that witness. That witness. So the policing concept, again, talk to Julie Gardo because she feels differently. But it's a thing you can rely on, but I still need that other witness in court.
Well, of course. Well,
Yeah.
it is your PSA, all right? Now, your PSA sees something, okay? Says, I saw this car move across our area. We're not talking about, a citation with feather top, okay? We're talking about it's legitimate, cross the line, 3/4 of the vehicle went in the shoulder, and he goes back on the traffic lane. I saw him do this 3 times. He went from dirt to dust everywhere. The PSA sees this. I don't see it. He calls me on the air and says, hey, look, I believe an impaired driver over here. Okay. I get out there. I don't see a thing except for the vehicle. He's described the vehicle to me. And what I would go in is under Galvin case. But this is what I got. This is what I found. And I stopped the vehicle based on the
Policing concept, yes.
what he said. And so I stopped the vehicle, even though I didn't see the violations. Now, obviously, that PSA is going to write a report.
Yeah.
I wouldn't touch it without the PSA writing a report and being, get a PTI, et cetera, et cetera. But I go ahead and do that investigation based on what the PSA saw. My question is the PSA enough or does it have to be different?
No, PSA is enough. Yeah. Any credible source of information. Yeah. So, okay, I'm understanding your question now. So, yeah, policing concept is other officers that you work with all the time are going to be a little more credible than you getting a call from some druggie saying, this is some information. Like, yeah, another person in uniform, regardless if they're a certified officer or a PSA or whatever they are, or even an admin driving home, I would argue that you can trust that person. Because that person is saying, I'm seeing this bad driving, and you get out there, you see the vehicle, and you don't see bad driving, you pull them over. That's probably going to be okay, but I need that other witness. Because we can't prove any of the bad driving without that witness. So yes, you can, again, make a decision in your investigation based on the information you have. Okay.
Well, that's like on the drug busters. Well, that used to be where you could go, if they called it in, you could use that information, but don't stop them.
But now we can't prove the bad driving without that. Yeah. And that might give you reasonable suspicion to pull over, but then we have to do with probable cause for what you did then. And that's what we're going to have to litigate, and whether or not that drunk buster's call is enough. Yeah. Let's see. Always read the Implied Consent Act. Let's see. I want to say that we were going to talk about a case. No, I didn't see it on here. So there was it happens probably a lot to you when you're reading the implied consent and the dude's just yelling at you. He's belligerent because he's drunk. And you're trying to read the implied consent act and he keeps interrupting you. And then you just give up and you stop reading and like, yeah, that's a refusal. And this was actually, I don't actually think there is an actual case on this. This is just what happened and what our Santa Fe magistrate judges have ruled recently on one of those. I think it was Judge Ryzanek. Judge Ryzanek said that, no, that you did not read them the implied consent. And so this is not ag DWI. I think you got bound over on the DWI, but not the ag DWI. So even if they're yelling at you, if you want to show that they refused, you have to read them the entire implied consent act. And that should be on your body-worn camera. And that looks great to a jury as you calmly say, you need to listen carefully. I'm about to read something important to you. If they're just blah, 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 like, it would be great. That's great evidence.
Yeah, typically, we'll read it like multiple times, then we'll explain it, and we'll read it again, and then if they keep yelling, we'll say, I take your action.
Yeah. After you go through those steps, though, yeah.
Yes.
Yeah. Let's see. Okay.
Yeah, he's my AI glasses.
All right, so some changes in the law. The red flag laws. This is going to be fun because nobody actually understands them. And a lot of this is not something we get super involved in our office, but we do have a designated person so that when we do get involved, this is the person to talk to. Her name is Gina Manfredi. So, okay, people have nodded. Yeah. Reach out to Gina for red flag stuff. It's weird what the red flag law is.
I got something I ran into a month ago. Yeah. So got a guy called. His wife moved to Denver. She filed a TRO on him. She's been living up there like a year and a half, close to 2 years. She files a TRO on him. They are going through a divorce out of Santa Fe County. But she's living up there for almost 2 years.
Mhm.
After they got divorced, she went and filed a TRO on him.
Yeah.
And the judge up there told him, or in this TRO, that he had to relinquish all of his firearms.
Yeah, it's standard for a TRO. Yeah.
But we got it like 7 days after the meeting.
Mhm.
So he was supposed to have been there like on the 10th for the hearing.
So he didn't timely turn him over, is what you're asking? Yeah.
No, I mean, well, on that TRO, he was supposed to have been in Colorado at the meeting on the 10th. We got it on the 17th.
Okay.
Yeah, we got it 7 days later after the meeting. But on that TRO, it says if you fail to show up, this TRO will be invoked.
Okay.
So, I mean, he asked me, he goes, "What do I do?" I was like, "Well," I was like,
it's a court order.
"Yeah, it's a court order." I said, "I'd speak to an attorney," but I say, "You didn't get the meeting in time or the notice in a timely fashion because it was 7 days after the court hearing."
Yeah.
But
okay, I see what you're saying. But you can't get involved too much in how the civil process happened. All you can deal with is the order in front of you, and deal with what you can with based on that. And any challenge he has to that, he's got an attorney and go back to the family judge to deal with that. Yeah.
Yeah, I never had seen that where, another state had ordered, and he's never even lived up there.
We had that here though. We got one in Oregon, and I got you guys guns.
Yeah.
Because we got this Oregon TRO, we get appropriation credit to their TROs.
Yeah.
So we will honor that when we get it. We took the guys' guns. Now the question was, after we take these guns, do we have to do a background check? Do we have to get someone with the FFL to give them back their guns? We do not. No, I call these in. There's nothing we can get them. We as sheriff department, they can prove ownership. They get their guns.
That seems scary.
I was just curious
It
because
is scary, but that's
Yeah.
I mean, the way that TRO read, it was going to invoke because he missed it, and then he hadn't complied with the court order to relinquish his firearms by that date. And so I was just kind of curious, about that because
It's not going to go well for him, and he's got to get an attorney. Yeah. There is a new statute now for modifying a semiotic firearm. I would also suggest reaching out to the feds because that's also a violation of a federal statute. Maybe the feds will take it. And I always want the feds to take as many of our cases as possible. I remember I had a meeting once with some federal guys for something that happened, and we met with them because they were going to take some stuff and whatever it was. And so I could tell when they came into the meeting, they were like, "Uh-oh," are they going to be like, well, we're going to be like, "No, this is my case. Back off. This is my jurisdiction." But it was actually the opposite. I was like, "Here, please take my case. Like, here, take it." And he was surprised because I was like, "You will get more time. You don't have the New Mexico Constitution getting in your way." So as often as you can, reach out to the feds and see if they'll take stuff. Let's see. The mushrooms. We did kind of sort of legalize them for medical purposes. So you got to know the statute. I think it still needs I don't know. Yeah.
So when are you going to legalize it?
As soon as the legislature gets caught with it, yeah, that's when it's going to happen. Aggravated battery upon a peace officer, it increased the penalties.
I'm sorry, this is the first letter.
Yeah.
So do you have to? So those, is it like marijuana, or essentially is it like marijuana, like it's legal? Or
I think it is. A small amounts I think are legal. we hardly ever see mushrooms cases, the psilocybin ones, and so to be honest, I'm not super familiar with it. Yeah. So yeah. So when you do have a psilocybin case, a mushroom case, call and we'll look up the statute. We'll walk through it together. All right. Let's see what else do I want to cover. Okay. I kind of want to finish up with how to write a clear PC statement, a clear narrative. But I've been talking for about an hour. I'm scheduled for 2 hours, so let's take like a 5-minute break so you can stretch your legs because I can see eyes glazing over.